Is liberty dying where you live? Escape to Keene at freekeene.com.
Which of the complaints that you're going with?
Your Honor, there's a handwritten complaint for criminal trespass that was signed by me.
Right.
That's active. There's a contempt charge. And the other criminal trespass should be dismissed or no charge.
Actually, there was a motion to withdraw that complaint before.
Okay.
I didn't hear that.
There was a motion, there were two criminal trespass charges. One was brought and signed by Officer Uhas.
Oh, are you talking about the amended complaint
Yeah,
where
yeah.
the
I just wanna make
prosecutor
sure.
inserted a word knowingly, maybe?
Well, there's one that's the contempt charge. I'll get you copies of these. Do you need these in front of you for the trial?
I would like to have copies of those.
Well, last time you were here on April 25th, I guess, when we had the issue about discovery, when your lawyer had withdrawn from the case. Is that the last time you were here?
Yes, it is.
That's one that was amended, and then it looks like the same date, the handwritten complaint. So there was an earlier criminal trespass complaint that's been withdrawn. We're not doing that one. So you have
Okay.
criminal trespass and criminal contempt. We also have a hearing. You didn't appear for a hearing on a remand, but we didn't, because we knew you were coming in. We didn't do a bench warrant. This was a hearing where you got a fine of $434 plus a 30-day sentence to the House of Corrections, suspended for 2 years on your good behavior. It looks like you appealed it, but never followed through with the appeal, so it was remanded back here for disposition of the sentence, or imposition of the sentence.
Okay, which case is this?
This was a marijuana possession from October 17th on Washington Street in Keene.
I've been waiting to be notified of the time of my jury trial for that matter. It wasn't an appeal, it was a jury trial.
That's correct, Your Honor. He failed to show up for his final pre-trial in that matter, and then Superior Court remanded it.
Well, it's been remanded here, so,
Okay, so what do we do with it?
well, we can address this afterwards. There's a fine and there's the 30-day suspended sentence. I'll just remind you what the suspended sentence means, but then we'll have to address the fine.
Okay.
We can do that after we do this.
Is there a way to kick it back over to court for proper scheduling?
Well, the only thing I can do is, if you feel that you were supposed to have been notified of something and weren't, but
Well, I've been calling the court and asking them if I was on the docket, and they've been saying no. That was the only procedure you gave me.
Hang on a second. So that was a Class A?
Yeah, I
Well,
called.
here's what we'll do. I can reset this for imposition of the sentence, okay, for 30 days.
Okay.
So in other words, you'll have to be back in 30 days. But during the 30 days, if you want to go over there and file some kind of a pleading to say that you should have notified me, I didn't get notice, that's the reason I didn't show up.
Mm-hmm.
Okay, and it wasn't your fault for not giving them a valid address or something like that.
Mm-hmm.
All right, so we won't impose a sentence today, but I'll schedule a hearing today so you know what the date is to come back. If they reopen your case over there, fine. In this case, we'll just wait until we see the outcome up there. But if you have a valid reason that, in other words, if they didn't notify you or some mail got sent back or something like that, then you probably have an opportunity to get your foot in the door again. But if they don't think you have a valid claim, then you'll have to come back here and deal with it.
Okay, groovy.
30 days?
Works for me. Will I get that in writing as well?
You can get it right now. January 1st.
August 1st.
It's probably still your place, but apparently you can use general delivery, so I'm going to start using that.
You ready to go?
Yeah, go ahead and leave it as is. I'll do general delivery.
You ready to go?
That was a former roommate asking me about address issues.
Yeah, okay, I understand, but are you ready to start? I mean, you don't need me to acquaint you again with the procedure that we go through for the trial, or you familiar enough with it?
Well, I've watched a lot of Law and Order. I think I figured it out. Of course, that's New York.
Yeah. All right, but once again, seriously, do you need to have a go through the procedure with you or not?
Yeah, go ahead.
Okay. All right, so the state will present how many witnesses?
2, Your Honor.
2 witnesses. As they go through their testimony, once each one is done, if you have any questions you want to ask them, you can ask them questions. You're not obligated to. When they're done, when the state's finished with its case and rests its case, it'll be your opportunity to testify if you want to, or to offer facts and evidence that I haven't already heard through another witness, perhaps. Again, you're not obligated to put on a defense if you don't want to. The prosecution has the burden of proof beyond a reasonable doubt on each of the cases. And if they can establish that standard, that's one thing. If they can't, that's another. So these are both Class A misdemeanors, so once again, you'd have a right to appeal if you were not successful here on either one of these today. Okay. Any questions about that?
No.
Your Honor, as a preliminary matter on the contempt charge, I would ask to move to amend the language. And at the end of the complaint, it says ordering the defendant to be of good behavior. I would strike be of good behavior, and in its place put in non-committed crime counted by committing a crime of criminal trespassing.
All right, the state's asking to amend the complaint. Do you have any objection to that? That's on the contempt charge.
Why does that make a difference to you?
Why does that make a difference?
Because the bail order says not commit a crime, the bail order doesn't say be of good behavior, although there's a Supreme Court case that defines good behavior as not committing a criminal offense. Nevertheless, for purposes of clarity, I wanted to track the language of the bill.
Well,
I'd rather stick with the wording that doesn't track the
well,
statute.
I'm going to take that as an objection. I mean, the state filed the original complaint in September. We had another hearing in April. It was amended at one point, and an amendment at this point is, I think, too late. So I'm not going to grant the motion. Does that mean the case goes out?
It depends on the court's interpretation of whether the Supreme Court definition of good behavior, which includes not committing a crime, is sufficient. So I'll proceed.
All right. I'm not going to allow them to amend the complaint because they've had plenty of time to do that. And they already amended it once. That doesn't mean that the case is going to be dismissed. The evidence may still support it, but I haven't heard the evidence yet.
Your Honor, I don't know if you recall, but we were here the last time, and Mr. Paul was here ready for trial. We had a number of witnesses. Mr. Paul asked for continuance.
Can I just ask, sir, one of the rules is the camera has to be in one position. It can't be moved. Are you happy with where you are right now?
I'm very happy with this position.
You can't be moving around. Okay, go ahead.
And based on that hearing, there was an agreement that a number of stipulations were entered regarding these cases.
Okay,
I just want to
remind me of
refresh
those.
it. Yeah. First is that this would be marked as State's Exhibit Number 1.
Oh, may I have a look at that for one more second? Okay. I object to the introduction of this document as evidence.
What's the grounds for the objection?
It does not refer to me.
Well, I don't know what it is at all yet. Let me see.
Okay.
Well, you can argue what it means, but there was a stipulation previously that this would be entered. As to what weight I should accord it, you can argue that later. I mean, I have no idea what the state's going to be using this for. So,
I didn't stipulate that the document was admissible. Was that one of my stipulations? I don't believe so.
That you were served with that by, well,
I was served with the document. I just object to its introduction as evidence. I do stipulate that I was served with it. It's just invalid.
Then it's what, invalid?
It is invalid.
Well, we can,
Or
I
does
guess,
not refer
my
to
understanding
me.
was the stipulation was that he was served with the no trespass letter, which would be introduced as an exhibit.
I do stipulate that I was served with it, but I still object to its introduction as evidence.
well, I mean, I didn't grant their motion to amend because that was taken care of. It should have been taken care of at the last hearing.
Mhm.
Similarly, these things were agreed to be entered as exhibits so that that the prosecutor would not have to bring in witnesses. It would streamline the presentation of the case, so.
I'm not asking
gonna-
for a witness that the document was delivered. I stipulate that the document was delivered to me, but it doesn't refer to me.
Well, as I said before, if you want to argue what it means and what it doesn't mean, you can argue that.
At what
Stipulate-
time?
Either during the presentation of your case or possibly at the end when the evidence has been submitted, probably the latter.
Okay, so
But-
either on cross-examine of the
Yeah,
prosecution
you can
witness?
cross-examine on the question, sure. I mean, if this comes in, if there's relevant testimony that you want to elicit from somebody, you can ask proper questions, there's no problem with that. What I'm saying is that I don't even know what this is going to mean until I hear all the evidence. But it's going to be admitted as an exhibit. What it means and how important it is yet to be seen. That's all it means.
Fair enough.
The other stipulations, Your Honor, is that, are that Officer Uhas arrested the defendant at the Cheshire County House of Corrections on September 9th of 2010. That Lieutenant Musso of the Cheshire County House of Corrections saw the defendant at the Cheshire County House of Corrections on September 9th of 2010. That this court's bail order in a different case, that being its bail order of June 1st of 2010, was in effect on September 9th of 2010. And I'm not sure if the court has that file, but and that the judicial notice of that bail order would be taken, and the judicial notice that the defendant was served with that order.
I probably have to have that here just so that the defendant can see it if he needs to.
10 CR 1363.
Okay, with that, you ready to go?
Yes. Okay, we call Rick Van Wickler. Please raise your right hand. You swear or affirm the testimony about the this matter will be the truth?
Yes, sir.
Please have a seat and introduce yourself for the record.
My name is Richard Van Wickler, V-A-N-W-I-C-K-L-E-R, Superintendent of the Cheshire County Department of Corrections.
And directing your attention back to June 1st of 2010, were you the superintendent of the Cheshire County House of Corrections back then?
Yes, sir, I was.
And how long have you been the superintendent of the Cheshire County House of Corrections?
Since June of 1993.
And among other things, as superintendent, are you charged with the day-to-day running of the House of Corrections?
Yes, sir, I am.
And prior to June 1st of 2010, did you request that the Keene Police Department serve a no trespass notice on Richard Paul?
Yes, sir, I did.
I show you what's been marked as states exhibit number 1.
Yes, sir, I'm familiar with the document.
Have you seen that document before?
Yes, sir, I have.
And did you request the Keene Police Department serve that document on Mr. Paul?
Yes, sir, I did.
And after that document was served on June 1st of 2010, did you ever give Mr. Paul permission to be at the Cheshire County House of Corrections?
No, sir, I did not.
Where is the Cheshire County House of Corrections located?
It is now at 825 Marlborough Road in Keene, New Hampshire.
And that's where it was back in June of 2010.
Yes, sir.
And did you give any of your employees permission to give Mr. Paul authority to be at the Cheshire County House of Corrections?
No, sir, I did not.
I have no further questions.
Any questions for this witness?
Yes. Are you an honorable man?
Objection, Your Honor, relevance?
Goes to credibility. Was that overruled?
Yes.
Thank you. Are you an honorable man, sir?
Yes.
Oh,
Okay. Is it a requirement of your job that you house prisoners without violating their constitutional rights?
Objection, relevance, Your Honor?
relevance.
Goes to each previous statement.
Sustained.
Do we have a problem?
Sustained.
Sustained?
Sustained. I sustained the objection.
Hmm?
I sustained the objection.
Okay. Do you regularly violate the rights of prisoners at your correctional institution?
Objection, Your Honor.
Sustained. Mr. Paul, you're going to have to get to the issues in this case. If you have other broader issues you want to address, this isn't the place to do it.
This all goes to credibility. If someone has shown himself to have a pattern of dishonorable behavior, is that not?
There's no evidence of that on the record here.
I'm trying to introduce it.
Well, I'm not allowing you to introduce it through the questions you're asking. Sustained.
Okay. Well, in that case, enough for him so far. Oh, I do have one question. Does your staff know that you are the only person who's able to override a trespass order? Because when I was ordered to report to the jail, obviously I had to call for permission before.
Hang on a second. It's just, you're asking a question, but you're also putting in testimony at the same time. Just try to put that in a form.
Okay, I'll be brief. Is your staff aware that you are the only person who's able to waive a trespass order?
Yes,
Okay. Is there a procedure for doing that?
yes.
Okay. Has your staff been trained on that procedure?
Trained?
Or do they know what that procedure is?
Yes.
Can you explain why, when I appeared to serve time at your institution and had to call ahead, of course, to get permission to enter the property because I was still under an order of trespass, none of your staff appeared to know how to contact you or that you had to be contacted for me to get permission to go onto the grounds? So what exactly is the procedure in order to get permission? What should I have done?
If one of the 12 people who were issued the no trespass order wanted for any reason to come on the property, they could have contacted any person at the jail and advanced that request. That request would then come to me, and I would either approve or disapprove that request.
Okay, so if I called your staff sergeant on duty, and I said, "Hi, my name's Rich Paul. I need to come onto your property to bail somebody out," your person on duty would say that request has to be referred to Richard. That request would have to be referred to the superintendent.
The only thing that's missing from your question is to identify yourself as being a person who has been served with a no trespass order,
Okay.
which would be required.
Do you maintain a list at the jail of such people?
We do.
Does your staff know where that list is located?
They do.
Do they have access to it?
They do.
Wouldn't the onus be on them to say, I mean, I'm asking if I have permission to come on, wouldn't the onus be on them to determine whether or not they were authorized by the procedures of your institution to give me such permission?
Well, the answer is it depends. We would have to know the exact question that you asked on the phone call and what the person you were talking to actually said. Did you give just a first name, or did you give your first and last name?
I gave first and last name.
Well, I'm just
Well,
saying, we
again,
have to
Oh,
know.
okay.
Again, that's not, I can't consider it as evidence. 'Cause you're
Sorry, we got it backwards. He was asking, I was answering, that's not right, okay. So if my full name was given, then it would be appropriate for me to believe that I have permission to enter that facility.
It would greatly assist us in doing what you expect us to do.
Okay. Were you aware that the night before I was arrested, I was also on the grounds of that facility?
No.
You're not. You didn't hear about any of the things that happened tonight?
I have no recollection of you being at the facility the night before you came to pick up that person from you.
I'm sorry?
I have no recollection of you being at the jail the night before you came to pick up the person where you were violated. I
Okay.
have no recollection of that.
Were you aware that there had been a dispute between someone and your bail commissioner in that the bail commissioner refused to bail someone that night?
Could you ask that again?
Okay. Were you aware of anything that happened the previous night? There was a pretty long confrontation where a woman was in custody. The bail commissioner refused her bail. We were trying to bail her. Then her lawyer contacted the jail, and the jail guards gave the wrong phone number to the prisoner to prevent her from contacting them. Were you aware of any of this, this stuff that happened in your jail the previous night?
I am not familiar with anything especially close to the version of your events of what occurred. I will say to you that we have at least 1,500 prisoners a year that we process, 365 days a year. There's a lot of things that goes on at the Department of Corrections, and I'm prepared today to talk about the details of you violating the no trespass order that I issued.
Okay. Let's take a look at that no trespass order. Can we do that?
Is that this here?
Yeah.
Sure. Do you have a copy of it?
I don't have a copy, but I could use the one on your desk if you don't want.
Well, just sometimes it's easier for you to have a copy to refer to.
Okay.
You need to say where you are.
Oh, okay. To whom does this trespass order apply?
Richard Paul.
Okay. And what is Richard Paul's social security number?
It's not listed here.
I see it listed. SSN right next to DOB.
Oh, I'm sorry. It's in a different colored ink on this.
It is.
It's a social security number that reads 0000917707.
Can I ask the court to take judicial notice that not only is that is just not my social security number?
I have no idea what it's not a matter subject to judicial notice. I mean, if you want to testify, well, it's not your turn to testify, okay? We just do things kind of a linear way here.
So maybe I can enter my social security card as evidence?
I don't know if you want that on your social security number on the record.
And I guess, Your Honor,
pretty.
Given the prior stipulation, I'm not sure of the relevance. Mr. Paul's already stipulated that he was served with that no trespass.
Oh, and I was served with this document. It just doesn't refer to me.
Well, as I say,
It refers to a different Rich Paul with a different social
as I said
security
before,
number.
the strength of the document is as a matter of evidence you can argue at some point.
At what point?
Well, as I say, probably toward the end of the case, when you're arguing what that document means, what weight I should give it.
Okay, so after the state rests, I should use that as part of my case?
Might be. I can't. I don't know how the evidence is going to come in. That might be an appropriate time. Certainly, by the end of the case, you'll have an opportunity to do that.
Okay, well, I'll just keep trying, and sooner or later, I suppose it'll be the right time. Okay, I'm done with this witness.
Sure. Okay.
Just one question. Are you familiar with Rich Paul?
Yes, sir, I am.
And is he here in court today?
Yes, sir.
Would you point him out?
He is this person here.
And the record reflects his identification.
Record will reflect that. Thank you.
Thank you, Your Honor.
They would call Sherry Barassa. Do you swear or affirm the testimony you're about to give in this matter will be the truth?
Yes, I do.
Please have a seat and introduce yourself for the record.
Before we proceed, I need to disclose that in probably the early 1990s,
Yeah.
okay, I represented Shireen and members of her family in an injury matter, and I don't know her otherwise. I don't socialize with her, never have. Do you have any objection to my continuing to hear the case?
I do. I'd like you to introduce yourself.
What's the basis for that?
The basis for that is that you have a prior business relationship with a witness.
What's your position on that?
Yeah, I leave it to the court's discretion about whether, and the court's in the best position to know whether it has a conflict. And it doesn't appear that an old prior representation would necessarily be a per se conflict.
Well, my problem is without, I didn't know, I don't look at witness lists, I don't know anything before a case starts. And somewhat related to that, there was a more recent conversation that I had with this potential witness that may make it difficult for me.
Can I ask the nature of that
No,
conversation?
it would be privileged, but I need to disclose that I may have.
So you continue to represent the witness?
No, I don't represent. I'm just talking about a conversation that we had about that may make it impossible for me to represent, to continue to do the case.
I don't understand. If you're not representing the witness, how can a conversation be under privilege?
Well, it can be a conversation related to prior representation. In other words, even though after I became a judge, I still did have documents, files, and things that I'm responsible for. And there may be some questions about those things that come back to me. I can't represent anybody, but I can refer, there may be a discussion about it as to where to find the file, what certain questions that might come up, and it's such that I don't think I think I would have to recuse myself based on the prior relationship. I apologize to everybody for the inconvenience here. I don't know to the extent to which this witness is critical to the state's case. I guess if she's going to be...
She's probably more critical to Mr. Paul's case, quite honestly, but he's asked me to recuse.
I think based on the circumstances, I think I have to.
And that's fine. I guess the only issue is procedurally, how do we go forward from here?
Well, it's in the nature of a mistrial. I would posit that it's similar to if you had a jury trial, you had a jury present, and something was said in court that wasn't supposed to be said, but the case hasn't. You don't benefit from double jeopardy because the case hasn't gone on. That you get a new trial.
My understanding is that jeopardy attaches when the first witness is called. Isn't that true?
It's true in a case in this particular court, but the reason for the termination of the proceedings is different here. It's not being terminated because of any irregularity in the course of the trial. You've asked me to recuse myself, and I'm doing that, so you can't benefit from that.
Fair enough.
So I apologize to you for the inconvenience and to everybody's inconvenience by it, but I think I can't go forward.
And just for clarity's sake, going forward, as far as who the state calls as witnesses to the next trial, the stipulations are still in full force and effect, that the state can proceed.
That'd be my position, that if I'm recusing myself, I shouldn't be doing anything more.
I would actually object to that. Those stipulations were...
What you'll probably have to do is file something. We'll probably give it to Judge Lane or a different judge to hear. But what you should do is not wait till the trial to raise those issues again. Those things have to be worked out beforehand.
Fair enough. Although I must say that I have even less idea about whether or not you have, in advance, I have even less of an idea about whether or not you have a business relationship with a witness than you do. You know, you don't know what witnesses are going to be called.
I don't have any present. I can't have any present business relationship with the private.
Okay, fair enough.
I can't.
But let's see what happens.
Okay, so you'll be notified. Did you get your notice on the hearing for?
Actually, I'd like to change my address with you.
Okay, we'll just put it on there.
Okay.
Should we pick a new trial date now?
Yes, you can have a
Paul's here.
You want to wait for a minute? Know who the judge is to schedule it?
Sure.
All right.
Yeah, Mr. Paul, let me give you, this is the, that other case, the remand where he said 30 days.
Okay.
That's your notice of hearing, okay? No, that's mine.
Oh.
I just need a blank piece of paper. Give me your current mailing address if you would.
Rich Paul?
We'd like to invite you to visit freekeene.com. FreeKeene.com features audio, video, and blogs chronicling the transition to a voluntary society. FreeKeene.com also has comments and discussion forums so you can be heard. FreeKeene.com.
I should be in Keene, New Hampshire with the Free Staters.